Hello, my name is Olorotimi Osha. Today is August the 26th, 2026, and it is actually Women's Equality Day. It celebrates the certification of the 19th Amendment in 1920, which gave women the right to vote in America. I've done earlier videos discussing the remarkable women called the suffragettes who made equal voting rights, including women, possible in America. You can look at those earlier videos. Today, however, in order to sort of also mark Women's Equality Day, I am going to discuss a remarkable young lady. Her name became synonymous with desegregation, Brown versus Board of Education. That's her last name. Her father was Oliver Brown, who had joined in a lawsuit uh, filed by NAACP's Legal Defense and Educational Fund against segregation in public schools in Topeka, Kansas in 1951. So I'm going to talk more about this case. It wasn't decided until 1954. And so initially, when this case was filed by the chief counsel of the NAACP's Legal Defense and Educational Fund, Thurgood Marshall, who went on to become our first black justice of the Supreme Court in the United States. Uh, it lost initially at the lowest court of the lowest federal court at the district court level. So it lost at the U.S. District Court level in Topeka, in Kansas. It lost there, and eventually, though, what Thurgood Marshall did was he consolidated a number of other cases, other similar cases that had been filed in different places in South Carolina, such as Briggs versus Elliott case that had a similar matter. They had the same issue that's with respect to desegregation of schools, black kids who were trying to integrate, all white schools and challenging separate but equal, which had come down from Plessy versus Ferguson in 1896, in which the Supreme Court basically said that separate was equal. I've done videos discussing that as well. So he consolidated a number of similar cases from South Carolina uh, and Virginia, Washington, D.C., and Delaware. With this Topeka case, Brown versus Board, and because of course Brown versus Board, the way the court dockets read, they read cases in alphabetical order. So Brown, of course, is was higher up in alphabetical order, and so that's why these consolidated cases dealing with desegregation came to get the name Brown versus Board of Education, right? So, and one thing I want us to get out of this discussion is to understand that um, the fact that you lose a case at a lower level at a court, so long as you don't accept a plea deal, right? And this is not legal advice, by the way. So long as one doesn't accept a plea deal, they maintain their right of appeal. So you can appeal to a higher court. For instance, I've talked about my travails in Montgomery County, Maryland, where I was wrongfully charged. I was no arrest warrant. I was raided by police based on a perjured emergency valuation petition in which I wasn't given any notice. And it's ironic that the police officers who shot me in the head, I was deemed to have frightened them, right? So Montgomery County jury, a rigged jury that was already biased. I'd already asked that I should have a change of venue since Montgomery County. I couldn't be guaranteed a bias-free, non-prejudiced jury. So since the community favored cops, and of course the court had already shown a lot of procedural unfairness, right? It showed a tremendous amount of bias, and I'd put this in the media that the judges in Montgomery County, including Judge James Bonifant, Judge B.B. Berry, were corrupt. And so there are people who had, it garnered some attention. And so there was a rigged jury pool, right? So the jury pool They had these preconceived notions. They already had their bias. So, um, but I never took a plea deal, right? The judges had attempted for over 3 years to coerce me to accept a plea deal, right? By making, bond conditions, harsh, severe, inhumane, right? A judge actually took my job from me, said it in court that he wanted me to lose my federal government job, to lose my job at the Pentagon, and he placed me under house arrest with a GPS for a long time. This is someone I was working in the federal government, no criminal history, nothing, right? And I was assaulted in my home based on a lie. I was a victim of a swatting that was manufactured by the police. But the reason why they filed these charges against me were to preclude a lawsuit against the police and against the state, because it was the police that the uh, manufactured the swatting in the first place. They suborned perjury, fabricated witnesses, did all sorts of fabrications, right? And then they suborned perjury through Jide Wari and the neighbor, right, to go and file false claims against me, right? And so it was a malicious prosecution, a prosecutorial misconduct. So the state attorney should never have filed the charges against me, because I was just an innocent man sitting in my home. But I refused to take the plea deal. But of course, Montgomery County courts, their judges are very corrupt. People like Judge James Bonifant, Judge Michael McAuliffe, Judge B.B. Berry, they're very corrupt. It's part of the rackets, right? They are a racket in Montgomery County, Maryland. And so Judge McAuliffe was able to steer the jury, right, to come up with a guilty verdict, right, for intent to frighten. Imagine the police officer who shot me in the head, right? I was found to have scared him in my home, where I'm protected by through self-defense and the castle doctrine. So they came up with a coerced guilty verdict, right? But I maintain my right to file an appeal, because that's a lower court, so it goes automatically to a higher court. And I was forced to go pro se, and I didn't give up my right to counsel. I maintained it throughout. I wrote it down. I said it in court. I'm not giving up my right to counsel. It's not voluntary. I'm being coerced. I'm under duress to continue to proceed to trial after almost 4 years. And it had already passed the statute of limitations. 3 years is statute of limitations, right? So I get to file. So automatically, the judge can change the verdict. It's up to him. But if he doesn't, automatically have a right of appeal, and it goes to a higher court. And typically, almost likely there would be a reversal. But hey, knock on wood, because Maryland does astonishing things. It's remarkably corrupt, fantastically corrupt. The judiciary is fantastically corrupt, and it's an old white boy network, right? And they have a bunch of people, so you can never trust them, right? And of course, they have their marionettes as well. But my point is that you have a right of appeal, right? You have a right of appeal when something is at the lower court. You can appeal a bad verdict, a decision, an outcome that you don't support, and that's your right. And so that was what happened in the case of Brown versus Board of Education, right? So at the U.S. District Court in Kansas, a three-judge panel found that they upheld the segregated schools, right, in Kansas. So Thurgood Marshall and the NAACP, they consolidated other similar cases, again from, like I said, from South Carolina, Delaware, Washington D.C., and Virginia, right? They consolidated them. So there are other families, and so they consolidated them and filed what's called a writ of certiorari. They filed the appeal to the U.S. Supreme Court, right, which is the highest court in the land, and the U.S. Supreme Court agreed to review it. And ultimately, what happened was, by a 9-0 decision, unanimous, everybody agreed. Chief Justice Earl Warren, the remarkable Chief Justice Earl Warren, he was the Supreme Court justice of the time, and they found that separate but equal was inherently unconstitutional, and they reversed the decision of the lower court at the U.S. District Court, And uh, Brown versus Board, right? It's become the moniker for desegregation. That schools for integration to integrate schools, and so that's the law. But this didn't come down until 1954. So Oliver, the father of Linda Brown was a little girl. She was a third grader at the time, so roughly 8 to 9 years old. She was really young at the time, and about 8 years old, right? So her father was Oliver Brown. Her father was a welder. He was an assistant pastor, and he was approached by NAACP that he should join in a lawsuit. His daughter had to walk past a white school called Sumner Elementary School. She had to walk past that and walk 24 blocks to a segregated black school at Monroe Elementary, right? That school was subpar, right? Because the law was in the South was that schools were to be segregated, and the law in America said that, well, if you have separate facilities, they could still be equal, so long as you make you give them equal resources, kind of, right? And of course, that wasn't the case. Now, the lower courts, the lower U.S. District Courts panel, the judges who upheld Plessy versus Ferguson, who said, well, the separate schools were equal. They gaslighted the public, right? They gaslighted the plaintiffs, the public, by saying, well, that they spend that these black kids and white kids in segregated facilities had similar equal facilities and resources available, that the quality of the teachers are equal. There's all sorts of stuff, that the facilities are equal. And then they said, well, yes, the black kids had to travel a long trip, but free of charge because the state paid for it. It was a free of charge. They were bused, in their long trips to school, to their segregated schools, but that it was free of charge. And the courts now gaslighted, the public, the black people, by saying that in fact they're getting a better benefit, an additional benefit that white kids don't get, because they get to be transported free of charge, but that's because the white kids don't need it, right? So they gaslight you, and the courts can be very disingenuous, right? Some of these judges can be very disingenuous in their decisions. So it was a horrible decision, disingenuous, and fortunately, it was appealed up all the way to the Supreme Court. And when it got to the Supreme Court justices said no, that separate was inherently unequal. And it was based on the Fifth and 14th Amendments, right? For Fifth, due process and equal protection of the law, so that it violated, that the segregated schools violated the Fifth and 14th Amendment rights of the black kids. So um, it's kind of remarkable that many times we don't know. We knew first generation um, African Americans. That's where I'm a Nigerian American, but because they're Africans who come from Rwanda, Africans who come from Ethiopia, Africans who come from South Africa, from Ghana, from Sierra Leone, also everywhere from Cameroon, including Nigeria, we're Africans collectively, and we're American citizens. We're first generation, and with our children as well. I don't have children now, but I have nieces, and that's the reason why I'm actually doing this video as well, for the benefit of my nieces, so they understand the history. Um, we don't understand many of us are not aware, we're not educated on the struggles, the long struggles that black Americans had to go through, their persistence by going through the legal system. Uh, Linda Brown, who her father filed for on her behalf, was an eighth grader. Now, by the time, although the courts eventually ruled in her favor, the Supreme Court upheld her right to attend a desegregated school, an integrated school. But by the time the court's decision came, like years after, this was in 1954, her father filed on her behalf in 1951. By the time the court's decision came later on, saying yes, it was constitutional for her to attend an integrated school, right? She was already past, the eighth grade, right? She was in ninth grade or eighth grade, whatever, ninth grade at the time or eighth grade. She had already grown past that. She was now actually in was it junior high or something, right? By the time this decision came about, so she never got to attend the school she wanted to attend. That was Sumner Elementary School, the white school that was just right next to her home that she had to walk past. She was not able to attend that school. She never did. um, she did, however, graduate from Kansas State University. I don't know if she graduated, but she did attend Kansas State University, which is even till today, it's a predominantly white school. It's roughly 79% to 80% white, and black students are, roughly just about 3%. But she did get to attend that school, and she became an activist, right? Later on in life, she was an educator and an activist. Now, again, even though Brown versus Board, right, uh, Board of Education would uphold the rights of Black Americans to attend integrated schools, the it was the laws, the policies were not the executive branches of this various states did not execute the policies. They didn't implement immediately. So, if you want to learn more about that, you could read All Deliberate Speed. I read that book, written by Professor uh, Charles Ogletree. He's late now. He was Barack Obama and Michelle Obama's mentor at Harvard. He was a professor at Harvard Law School. So read that book, All the Deliberate Speed, if you want to know the mechanics and the long journey of desegregating. It took a long time. Many schools didn't desegregate all into the 70s, some even into the 80s, right? There was a lot of violence and a lot of resistance against it, busing and whatnot. If people remember the debates, the presidential debates between Kamala Harris and Joe Biden, when Biden was running for office for to be number 46, Kamala Harris did mention the busing issues. So busing was a problem back then. I could do another video talking about busing, but so implementation was a nightmare. It didn't happen immediately. In fact, um, while Linda Brown never got to attend the school she was trying to attend, that's Sumner Elementary, her children, she remained in Kansas, right, in Topeka. Her children also could not, she had to file a new lawsuit, renew her lawsuit, right, saying segregation continued in schools in 1979 on behalf of her children, right? 1979, this was, we're talking about some 25 years after the Supreme Court said, okay, integrate schools. So it still hadn't been done in Topeka schools. And so Linda Brown, the child that her father had filed on behalf, the NAACP, and her father filed on her behalf when she was just a little girl, about 8 years old, and she never got to attend the school she wanted. Now she was a grown mother. She had children. In 1979, her children were attending schools, and she was filing a new suit with this. She renewed that suit with the court, saying her kids were still attending segregated schools. This was in 1979. Well, the Court of Appeals in Kansas would support her, but again, the fact that it went to the Court of Appeals, you could see that she was denied at a lower court. But anyway, a decision favoring her, favoring desegregation again, upholding desegregation, uh, did not come until 1993, right? So 14, we're talking about 14 years after she filed. So you see the wheels of justice move very slowly, unfortunately. I was a victim of police misconduct, prosecutorial misconduct, and the abuse of Jide Wari, who filed a malicious and fabricated emergency evaluation petition against me. In 2023, I was a law-abiding American citizen in my home. I was violated. They almost killed me. I was shot in the head, right? You see, I have permanent nerve damage here now. And these permanent scarring, these are scars, not wrinkle lines. And I woke up with marks, bruises all over my body. I was brutalized by the police in my home. I'm not a drug dealer. I'm not a fraudster. In fact, I was working in the United States federal government and the Department of Defense. And this bully, this lunatic Howard University professor, Jide Wairi, who's delusional, calling himself my uncle, goes to uh, work with Montgomery County Police, and they manufactured a fabricated emergency evaluation petition, telling lies, and other, with a neighbor assaulted me and filed false charges against me. Now it's taken over 3.5 years for me to be in court, and I didn't have an attorney to assist me. So you see, there are a lot of injustices that are in America, which Black Americans have had to face. They've had to navigate for a very long time. And Black Americans were filing lawsuits even during the era of slavery, right? They would file freedom suits during the era of slavery. The popular uh, Dred Scott case, Dred Scott versus Sanford, right? Which came in 1857. The Chief Justice Roger Taney from Maryland, right? Infamous Maryland, right? With the racist decisions by judges that they believe Black Americans and people of African descent cannot be equal citizens. That's what Dred Scott decision of 1857 did, and historians believe that was what the straw that broke the camel's back, which led to the Civil War. So Linda Brown, again, like I said, she would have to renew her lawsuit on behalf of her children. And this wasn't decided on her behalf until 1993. A court of appeal in Kansas, decided in 1993. So you see how slowly justice moves in America, right? Again, what they say, Barack Obama likes to quote Reverend Martin Luther King. The arc of the moral universe is long, but it bends towards justice. He was quoting somebody else as well, by the way. So I wanted to just talk about, the case of Linda Brown. And many of us don't know Linda Brown was a young girl. I thought it was appropriate to discuss that today on Women's uh, Equality Day, marking the achievement of the 19th Amendment and voting rights of women in America. Uh, in fact, many movies that I saw, and when professors have discussed it, they make it seem like Brown was a young boy. And I think it's conflated because of the other cases. The other cases, like the case of Harry Briggs in Briggs versus Elliott, right, in South Carolina, the plaintiff, was on behalf of a young boy, who was also having to travel a very long way to attend a segregated school in South Carolina. But Linda Brown versus Board of Education, that's Brown versus Board of Education. Her father was Oliver Brown, filed on her behalf because, of course, she was a minor, so that she could attend integrated schools, attend the white schools. And that benefited the rest of us, right? All the schools I've attended in America were predominantly white schools, whether it was Troy University in Troy, Alabama. Um, in fact, the Congressman John Lewis was born in Troy, but he was denied entry into that school's library or to attend that school, right? And so I benefited from Brown versus Board of Education, the integration, the work of integration that Black Americans did, prior to me coming to America. I attended Columbia University and graduated from there as well. And I also graduated from George Washington University Law School in uh, DC. But you see, many of these schools still have elements of, they still seem very segregated, right? So there are all these obstacles, right? These little obstacles that are in place just to continue to prevent blacks from being able to attend predominantly white schools in America, which have more tax dollars, better facilities, and even when you're there, you still experience hostility. Linda Brown continued to experience hostility even as she attended an integrated school later on, right? Kansas State University. So, and this is something that many minorities have talked about, of in terms of their experiences. So, racism is still very much entrenched in America, and the irony is when you're talking about you're trying to affirm or assert your right to equality, racists, there's that blowback from racists who now say, oh, all you do is complain. What racists want is for you to just eat up racist or disappear and, look for something they can do. But it's your right, it's your freedom of speech to assert your rights. That's your First Amendment right. And you're asserting your right to equality, equal protection of the law. And that's your 14th Amendment. My name is Olurotimi Osha, and I will keep you posted. Thank you.